Namaste dosto, I am Anil Goel from AAA Insolvency and today we are delivering voice number 2 from our series called Voices from Courtroom. Today we are discussing a pivotal judgment from Delhi High Court delivered on 26th of April 2024 in the insolvency process of Go Airlines. Very important judgment with regard to the insolvency of airlines and the overall airlines industry in India. The judgment is from Delhi High Court. In this case, the applicants are various international aircraft leasing companies. In the case of Go Airlines, and the respondents are Union of India and Directorate General of Civil Aviation, DGCA in short that we can call. Now, the facts of this case was that the aircrafts were leased to Go Airlines and the insolvency started on 10th May 2023. However, all these leasing companies immediately and in fact expecting such kind of order 7 or 8 days before the commencement of insolvency, they terminated their lease agreements and immediately applied for deregistration. Now, they can apply for the deregistration as per the Rule 30 Sub Rule 7 of the Aircraft Rules 1937. In that, as per that rule, DGCA must deregister the aircraft without needing the airline's consent once the conditions are met. So, in Rule 30 Sub Rule 7 of Aircraft Rules 1937, there are some conditions which are mentioned. In case those conditions are met, then the lessee does not need to give a consent. At the application of the lessor, the deregistration can happen and the lessor will take away the aircraft to his control and custody. Now, in this case, the respondents, in fact, DGCA and the Union of India, they contended that the moratorium under Insolvency and Bankruptcy Code encompasses all assets preventing the deregistration during the IBC. They argued that any decision on deregistration should be decided by the NCLT and not by DGCA because the insolvency has started and by that time the deregistration has not taken place. The application was pending before DGCA. Now, in this case, the legal issue which was involved as per this High Court judgment was that whether IBC's moratorium could override the provisions of Aircraft Rules 1937 and international treaties like Cape Town Convention, where all these international airlines, how they would do business, that was decided. The court also considered whether DGCA action were administrative or quasi-judicial. Now, in this case, in fact, the Justice Tara Vitasa Ganju held that the moratorium does not extend to deregistration of aircraft, thus siding with the lessors. The lessors are happy. The judgment emphasized the supremacy of the international treaties and also the specific provisions of aviation law over general insolvency procedures. Now, but this particular judgment has impact on the industry, not on the IBC, but it has the impact on the aviation industry in India. This ruling actually will reinforce the rights of aircraft lessors during the insolvency proceedings. It also ensures that the international norms and agreements would be upheld. It also ensures that the international financiers' security and clarity, and therefore the Indian airlines will get more and more leases at comfortable pricing. Now, in case this moratorium would have been applicable, then the international lessors would refrain from leasing to Indian airlines or they would add risk premium. Therefore, the other airlines, overall aviation industry is happy. But one conclusion that we have to draw, one, that the international treaties are supreme and IBC does not override. Similarly, any kind of sectoral specific law that also may or may not be kind of subservient to IBC. So IBC may not prevail on all these laws. Therefore, this judgment actually have settled. Maybe the Supreme Court again will say something, but for the time being, this is actually a scenario which is a happy scenario for overall aviation industry. Thank you for your attention. This is our way of learning.